with respect to veterinary practice. It did not do it with respect to the practice of medicine. The administrative officer, in her ruling, believed that the legislature only intended to protect the public, and therefore it was unreasonable to interpret the practice of medicine with respect to dead persons, not live persons. Well, as we've argued, there's no support for that in the statute, but also we all know that when medical examiners perform autopsies and get the results of autopsies, that whole practice of forensic pathology has many, many results for the public. It's been used to help in Legionnaire's disease. It's been used for statistics. In fact, one may say, as a number of the experts who are included in the record said, that the work of the medical examiner and the work of the pathologist has a great deal to do with the public at large and with our dealing with disease and fighting disease. To think that the legislature in this statute intended to take a specialty of medicine, forensic pathology, and exclude that from any oversight by the state medical board, I think is not only unreasonable, but it's not consistent with a sound public policy. Our argument essentially is that the terms of the statute do not support the petitioner's argument, that the regents interpreted the education law, due deference should be given to the judgment of the professionals in this case. The Commissioner of Health, who recommended a similar determination, is a physician and relied on sound medical practice and knowledge as well as an application of the statute, and that determination should be upheld by this court.
Thank you very much, Mr. Wickham. Datiz versus Shoob.
Ready.
Mr. Marrow, I assume that you're now going to retrace all the evidence in this case for us to convince us that there wasn't a case made out?
I hope not, Judge Walker, unless, of course, it supports a point that I'm trying to make.
We are basically a law court, and although insufficiency would make it out, with all the presumptions that flow from a jury verdict, there are some problems for you here. Please proceed.
Thank you. Within 20 hours of this child's birth, this child was examined by a board-certified orthopedist. At issue here is the timely referral to an appropriate specialist. Now understand...
She was examined by your client within even fewer hours than that.
That's absolutely true, although you know we're talking about congenital hip dislocation, which need not be diagnosed until weight-bearing. And very frequently, in fact, probably more often than not, is not diagnosable at birth.
Well, was that the proof? Do you mean there was no evidence of any potential damage resulting from this failure to diagnose immediately?
Yes. Yes, Judge Bellicosa, that actually
No,
is the
no.
proof. If you want to turn...
I'm just a visitor. This is Judge Bellicosa.
Oh, I'm sorry.
They look very much alike, though.
We don't necessarily agree on everything.
Okay.
We're here to be educated.
My mistake, sorry. To deal with the issue of proximate cause, which is one of many ways of approaching the problem here, plaintiff's own pediatric expert, Dr. Cherish, testified, although initially he said, and I will admit, initially he said it was diagnosable at birth in the majority of cases. Later on he said that it possibly did not exist, does not exist at birth, and in this case he said, I don't think it did. All right. It is also well known as to congenital hip dislocation that it need not be diagnosed well within the first year. In fact, pediatricians, as a rule, check for this over the course of the first year. And as long as it's diagnosed before weight bearing, the treatment is relatively simple and there are absolutely no injuries. The unfortunate thing is if it's diagnosed after weight bearing, in this instance at age 3.5, then you have problems and you need surgery.
Does that mean that any physician who examined the child before that age would be exonerated of responsibility for failing to detect it?
No, just the opposite. Any physician as you get closer and closer to weight bearing, and when it's more readily diagnosable or capable of being diagnosed, those physicians, and I think if my recollection is correct, the facts in this case show that no less than 7 physicians examined this child prior to weight bearing. None, unfortunately, diagnosed congenital hip dislocation. And as you know, for Dr. Shoob, my client here, he only had 4 days, the first 4 days of life.
But as I recall, there was a great deal of testimony with respect to the so-called Barlow maneuver. And the jury could have very well credited that testimony, which indicated that it was not performed.
Absolutely.
And that could constitute malpractice.
As my adversary says, it was a hotly contested issue. But even if we decide, along with the jury, that in fact the Barlow maneuver was not performed by Dr. Shoob, look at the rest of the facts in this case. It's undisputed that Dr. Borstein, the orthopedist who was called in within 20 hours, did do a Barlow maneuver. Absolutely undisputed. He still didn't diagnose it. And in fact, for 5 months, he continued to see this child and do the Barlow maneuver. And you know what? He wasn't able to diagnose it. In fact, plaintiff's own expert, Dr. Cherish, says it probably would have been diagnosed at 8 months of age. That's at page 660. If all procedures and maneuvers were carried out correctly, it would have been diagnosed at 8 months of age. As you may know, the orthopedist, Dr. Borstein, stopped following this child at 5 months. And that's the problem here, of course. You know, I would even argue, in reference to your question, Judge Wackler, that assuming, again, he didn't do the Barlow maneuver, did he have to when he called in a substitute who would do the Barlow maneuver right then and there? And again, all of plaintiff's experts agreed that the proper thing is to call in the orthopedist who has the greater expertise in orthopedic problems and conditions. Dr. Shoob never undertook to treat the plaintiff's orthopedic condition, and as I said, within 20 hours, called in a board-certified orthopedist to make sure that he would be followed, had x-rays done, all within the first few days. I think exemplary behavior. In fact, at the time of discharge, because of the nature of this particular problem, that it has to be followed, because you may not diagnose it early on, and as I said, it doesn't have to be diagnosed early on. But because of this particular problem, a pediatrician at discharge went to the orthopedist to ensure himself that the child would be followed by the orthopedist, and the child was followed by the orthopedist. Again, as I said, plaintiff's expert going to the idea of proximate cause, and there are many ways to approach this. Plaintiff's expert said it probably wasn't diagnosable until 8 months of age. Dr. Shoob only had the child for the first 4 days. And as I heard earlier today, interestingly enough, in the first case, when plaintiff's attorney was asked about the liability of a referring
Seems like
physician.
a long time ago.
It seemed like a long time ago, but I remember it. He said a referring physician, interestingly enough, might be liable if he continued in the care of the child. And as we know, in this instance, Dr. Shoob did not continue in the care of the child. He saw the child, he saw a potential problem, made the referral to the board-certified orthopedist, assured himself that the orthopedist would follow him, which he did. By the way, he also, exemplary, I think, in pediatric practice, had x-rays performed of the child just prior to calling in the orthopedist, so everything would be ready to look at. By the way, the radiologists weren't able to diagnose it either. And there was, you know, it must be more than strange that there was no diagnosis, not only by Dr. Shoob, but by the orthopedist, and by all of the physicians following. It may very well be, as plaintiff's expert himself testified, that it would not have shown up until 8 months of age.
Mr. Morrow, apart from the facts and the theories, how would you extrapolate and frame the precise law question which we're being asked to decide based on the appellate division's grant of leave?
I see many. The first, I would say, is the liability of a referring physician, which Grady is the only case that discusses it. It's an old case. It was cited by the dissent.
But just
Yeah.
to stay with that question for a moment, your client's liability is not as a referring physician. It was for his own treatment of the child.
Well,
It's not-
That's why, as I began to say, there are many ways of looking at this. Addressing
I'd like you to give me one precise, predominant, put it in your hierarchy and priority of law questions.
I wish I
that would be
could.
decisive of this case.
I wish I
that we-
could. I'll give
We got
you-
to start there at least,
I'll
don't
give
we?
you two. All right, there are probably even more. There are two. One is the liability of a referring physician that I was attempting to explain. And please understand, I'm talking about the immediate and timely referral. This is the more common referral, but to be distinguished very importantly from two very other, maybe not so obvious kinds of referrals. That is the delay in the referral. That's not a timely referral. Where there's a delay in possible diagnosis or delay by the initial treating physician, a delay in realizing that a specialist must be called in. Typically the tumor that could have been discovered earlier and it's cancerous and time is of the essence. Well, then you've got a referral, but you've got a referral late in time where arguably the initial doctor is an initial tortfeasor in that he delayed getting the necessary treatment to the patient. That didn't happen here. There was no delay in the referral. The other kind of referral that has to be distinguished out is the referral to a specialist to take care of a problem caused by the initial physician. In other words, lack of skill. Physician, surgeon severs a nerve, calls in a neurologist or something like that. It's important to understand here the distinction from all of the cases that are relied on heavily in plaintiff's point 2, where he talks about initial tortfeasors and subsequent tortfeasors. By the way, the defendants have no problem with all of the law as cited, except that it doesn't apply here. And I think the key distinction is that the general practitioner would be responsible for harm resulting from the specialist treatment or lack of it, only where his or her own negligence caused the harm or injury which itself necessitated the specialist. That's what's cited in my brief, and that's what's missing from plaintiff's brief. Another way is to say where the initial party, that is Dr. Shoob, arguably caused the need for that treatment. All right? Dr. Shoob didn't cause the need for any treatment here. He's not an initial tortfeasor, and you see my adversary, once he starts talking about initial tortfeasor and subsequent tortfeasors and contribution and everything else, is assuming the malpractice. Even if there was a departure, there's no proximate cause, and that's the second potential issue of law here, whether there was proximate cause, given the facts in this case. Sometimes it's a jury issue, but sometimes, as has been, I think the case is Monahan. I'm not sure about that, but I can look it up. There is a case that says that there are times that the issue of proximate cause is a matter of law. And now clearly, to go head on to the appellate division's decision, the majority found that there was proximate cause, and the key phrase, I think, in the majority's opinion, is that the diagnosis would have facilitated treatment by the orthopedist. That's what they're saying. What I'm saying is, firstly, this is against the weight of the evidence on all the grounds that I've just mentioned, that the Barlow maneuver was performed and repeatedly performed by the orthopedist. Nothing came up. It was probably not diagnosable to 8 months of age. Dr. Shoob only had the child for the first 4 days, didn't continue in his care. No diagnosis was made by subsequent physicians, and Dr. Shoob made certain that the child would be followed.
You're not suggesting we can review the weight of the evidence with the appellate division's affirmance of the findings implicit in the jury's verdict, are you?
I'm suggesting that, as has been held, probable cause cannot be satisfied by mere conjecture and speculation, which are no substitute for proof. And it seems that that is what the appellate division has done. There is no proximate cause. At best, the appellate division's second department statement that it would have facilitated the treatment by the orthopedist is high speculation and conjecture, at best. And that's no substitute for proof, and that's what I'm saying. To drive this home, it's important to also understand, absolutely important to understand, that the orthopedist testified that had he been told by the pediatrician, by the way, I found congenital hip dislocation, he said he would have never relied on that. He did, in fact, perform his own physical examination and make his own diagnosis, and he would only commence treatment based on his own diagnosis, and it would have made no difference whatsoever. There's a case on point to this precise testimony. I just became aware of it this morning. Unfortunately, I don't have the site. I vaguely remember it, though. Minardo versus Museo, which held exactly this, that the pediatrician in that instance said it would not have made any difference what he was told. Again, what you have here is an independent decision made only by the orthopedist to commence his own orthopedic treatment, and certainly taken out of the realm of the pediatrician, Dr. Shoob. So, again, there just is no way of finding proximate cause.
Thank you very much, Mr. Morrow. Mr. Hyman, what about the question of proximate cause?
Well, I think that I accept Judge Kaye's insertion in her question that it is a question of fact for the jury ultimately. It's not always an easy question, to be sure. When you have two separate events that led to, both led to the same condition. And by the way, the issue of Dr. Borstein not having noticed any hip dislocatability, I don't have to remind the court that the jury found against Dr. Borstein and socked him with 60% of the verdict in this case. So there's a serious question of credibility whether Dr. Borstein administered the Barlow maneuver at all or whether he did so properly. His failure to diagnose, of course, resulted in the verdict against him. It's almost suggested between the lines by Mr. Morrow that if the orthopedist didn't find it, how can you blame the pediatrician? But of course, they were both found to have malpracticed by the jury. I think that the issue is fairly resolved by asking the jury to consider all of the elements of what a proximate cause is, that it's a substantial factor leading to the injury. None of the defendants below, and certainly not Dr. Shoob, challenged Judge Sachs charged the jury on what proximate cause means, and also the jury was correctly charged about concurrent proximate causes, and they resolved this issue. And I don't think this was going to be my final comment, but I think it's appropriate to make it here. Now, I don't think that it's wrong to look at this issue in a complete vacuum now that we have the statutory right of contribution of the tortfeasors against each other. The jury, I think, was manifestly fair and I think very judicious and wise in its apportionment of the damages, and Dr. Shoob was assessed with 10% of that. Dr. Borstein, the malpracticing orthopedist who came later, was assessed 60%. And I should point out also that we talk about, as Mr. Morrow has the expertise of the orthopedist, the Barlow maneuver was invented and developed by a pediatrician. It is the pediatrician's job in the first instance, on that first examination, on the critical day of the infant's birth, to determine not just whether the hips are dislocated, which is the Ortolani maneuver, but also whether they are dislocatable, and that's the Barlow maneuver. And I dare say Mr. Morrow has, I think, mischaracterized the testimony, and I think unfairly so. The reference to page 660 is on cross-examination of Dr. Cherish, our pediatrician, our pediatric expert. He said that by 8 months, with reasonable certainty, this condition would be discoverable. But he said that earlier in his testimony that clearly, based on all the factors that were evident from the records alone, that it is highly unlikely that this condition would not have been diagnosed had the proper procedures been used by Dr. Shoob on the first day or within the first 4 days. So that's where we are with respect to the testimony.
Is the Barlow maneuver something that's within the expertise of the pediatrician?
Absolutely. It was Dr. Barlow was a pediatrician, and the pediatrician
It's not an orthopedic.
Well, it is also, of course, used. It's used by both without question, Your Honor. And by the way, when we talk about this concept of referral, I just would point out, I'm almost would like to have a blow-up of this, that it's at page 1901 of the record. The reference of Dr. Shoob to Dr. Borstein was nothing to do with hips. It was for examination and treatment of, and I quote, the doctor's handwriting is even legible from the original, evaluation and treatment of right knee and right ankle. And that was it. There was no discussion between the doctors after that. There was no a warning to Dr. Borstein about the concepts that, as a pediatrician, Dr. Shoob knew of with respect to the infant being a girl, being much more susceptible, and the global nature of the hypotonic or hypotonicity is the term for the general laxity of ligaments of this infant. It's an unusual case because the timing of the two examinations was indeed close. But we're left with a finding by the jury that Dr. Borstein was negligent. Having been resolved against Dr. Borstein, I dare say Dr. Shoob cannot rely on that as a break in the chain of causation. He indeed himself was a substantial factor in causing the condition to be undiagnosed for a period of time until, unfortunately, of course, it became untreatable in a benign way and had to be the subject of corrective surgery. I think I've essentially made the points I wanted to make. I dare say that if the court has any other questions, I'll be...
Thank you very much, Mr. Conway.
All please rise.
Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in for the State of New York, may now depart hence and appear at the next scheduled session of this court, to which time this court now stands adjourned, unless sooner convened by the Chief Judge or the Senior Associate Judge present in the State.
Good afternoon.